Yet another organization is seeking relief from the Constitutional Court over the constitutionality of the newly signed Electoral Act. One South Africa movement is challenging the number of signatures required for independent candidates to stand in next year's general elections. This is the latest in two challenges at the Apex Court. Experts warn that looming court battles and limited time could impede the Independent Electoral Commission's ability to hold free and fair elections.
Unfortunately, they're going to have a serious impact in terms of the IEC's capacity to deliver a smooth election. As you may recall that when the Electoral Commission prepares for the elections, it requires at least 24 months to prepare for the elections. And the uncertainty that has arisen as a result of this will create great difficulties for them because they've got to prepare logistics, they've got to train the electoral staff, and they've got to make sure that all other processes in the electoral process are catered for. And unfortunately, the uncertainty will create great difficulties for them to be able to deliver free and fair elections.
The amendment of the Electoral Act was necessitated by the Constitutional Court's judgment that found the Act unconstitutional for not allowing independent candidates to contest. The Apex Court ordered Parliament to remedy the situation. President Cyril Ramaphosa signed the bill into law in April, much to the disapproval of dissenting voices.
The responsibility to pass laws rests with Parliament. IEC only administers laws that have been passed by Parliament. As we understand the Act as it currently stands, an independent means an individual. So if you get more votes than what qualifies you for a seat, you'll certainly get the seat, and unfortunately the other votes will not go towards any representation. However, because parties submit lists of candidates, they are able, in that instance, to aggregate seats because you can assign those seats to other members of that party, whereas an independent is only a single person. So if they win 3 seats, they can't hold 3 seats being a single person.
Earlier this year, the Independent Candidates Association also headed to the Apex Court to lodge their grievances over the new act.
What they've done is they've actually made it impossible for independent candidates to stand in, and because I'm chairman of an independent candidates association, I have to look after their rights.
Yeah.
So now Leanne Manners wants to stand as an independent candidate, and now there's regional elections. Leanne Manners, to get elected in Gauteng, must get 91,000 votes.
Okay.
Where in previous elections, the parliamentarians that are there need to get 43,000. But what they've done is independent candidates in Gauteng must get 91,000, but a political party, if they want to get into parliament, they get 43,000 votes, which means that there's a 114% increase in what independent candidates must get.
The Constitution stipulates that elections be held every 5 years, and if there is to be an extension, South Africans must head to the polls within 90 days of the expiry of the 10 years of office bearers.
I assume that if the current Electoral Act is also declared invalid, I would expect the IEC to approach Parliament and then request Parliament to change the Constitution in order to allow them to have an election outside the constitutionally stipulated period. Because at the moment they're operating within a very tight time frame, and I don't think if the Electoral Act is declared invalid, they would actually be able to do these elections within a constitutionally stipulated period.
South Africa expects to head to the polls in May next year. Zoleka Kotashe, SABC News, Johannesburg.